Hi everyone, grab a drink and settle in. This is the Wills and Spills podcast, where we sip cocktails and unpack the most fascinating estate disputes behind the court judgments. The podcast is about real people, real family disputes, and the wills that have sparked them. Now, to help me spill the story behind our first case, I have Jonathan McCoy. Jono is a barrister who practices in this area of law and has extensive experience in running will dispute trials. So, Jono, what case are we unpacking today?
Hi, Linda. Thanks. We're talking about a case called Re Robustelle, number 2, because there was an earlier decision on procedure, but number 2 is the interesting one. The citation, for those who are interested, 2023 VSC 72. It's a case about validity of a will, a dispute about validity of a will, 2 wills, in fact, that were disputed. It was commenced by an objection to a grant of probate by lodging a caveat. Now, there are 3 sort of common grounds for caveat disputes or for objecting to a will. Those grounds are lack of testamentary capacity, undue influence when making the will, and a lack of knowledge and approval. And lack of knowledge and approval is a bit of a catch-all. It includes things like suspicious circumstances, more or less whatever you can throw at it. They're the 3 common grounds. This case involved just the first 2, the lack of capacity and undue influence. There's also, people often allege fraud in these cases too. That's a sort of a 4th ground, but that's very specific about the signing of a will, but doesn't arise in this case.
Yep. So, look, there's a lot to unpack in this case. But before we do that, I just want to provide a brief background to the case, just for our viewers. So the deceased Clarice, she died in March 2021 at the age of 91. She had a farming property and was actively involved in the farming activities. She was assisted by a man called Stephen Aikens. Now, he worked on the farm for many years. He also lived in a house on her property with his partner and son, Bryden. At the date of death, the deceased did not have any children and she was not married. She had a few nieces and nephews. During her lifetime, she made 4 wills. So 1 will in 2004, 2008, 2012 and 2018. But for the purpose of this case, we'll focus on her 2 later wills. So deceased made a will dated 22nd of August 2012. We'll call that the 2012 will. Then she also made a will dated 1st of March 2018. We'll call that the 2018 will. So in the 2012 will, the deceased appointed Stephen and her cousin Kevin as executors and distribute bulk of the estate to Stephen. But in her 2018 will, the deceased appointed Stephen as the sole executor and distributed the bulk of the estate to him. But if Stephen failed to survive her, then it would go to his son, Bryden. Now, Stephen died, unfortunately, before the deceased, and he died in February of 2020. The deceased did not have an alternative executor in a 2018 will. So Bryden applied for letters of administration of the 2018 will on the basis that he was the main beneficiary of her estate. Now, this is where your client comes in, Jono. The deceased's niece, Jeanette Clark, lodged caveats to prevent Bryden getting a grant of letters of administration of the 2018 will and subsequently the 2012 will. So what grounds was Jeanette alleging?
Yeah, so Jeanette alleged 2 main grounds. The first was lack of testamentary capacity. Now, that allegation attached only to the 2018 will. So you mentioned she was disputing 2 wills, 2018, 2012. The 2018 will, she said that Clarice lacked capacity when she made that will. And we'll get into more detail about exactly what she said, but there was allegations of delusions and medical issues, things like dementia, over time that were present when the 2018 will was made. And that formed the basis of the allegation that Clarice lacked capacity to make that will. The second ground that my client alleged was that both the 2018 will and the 2012 will were affected by undue influence, so that Stephen Atkins had unduly influenced Clarice to make both of those wills. And again, we'll get into more detail about exactly what that means, but broadly speaking, those are the sort of juicy allegations that come up in these cases. Things like threats of violence, aggression, really, significant moments that my client said affected Clarice's mind, so to make these wills in the favour of Atkins. And so that was the key allegation that affected both wills, 2018, 2012, the undue influence allegation.
Yeah. So Bryden applied to the Supreme Court to remove these caveats that she had lodged. So he argued Jeanette did not have standing to lodge these caveats. She wasn't a beneficiary in the 2012 will, and she wasn't a beneficiary in the 2018 will. So therefore, she lacks standing to lodge a caveat. Now, we often get inquiries from clients who want to challenge the will because of undue influence or lack of capacity. And there are times I've had to say to clients, I'm sorry, you don't have standing to lodge a caveat. In Jeanette's case, though, the issue of standing was dealt with in a previous hearing. Can you explain to us how Jeanette actually had standing?
Yeah, so standing is interesting, and it broadly across many areas of law, standing is an issue. But in estate litigation, it's a common issue because there's authority that says estate litigation is interest litigation, right? So you have to have an interest in the estate to bring a dispute about the validity of a will or the appropriateness of a grant of probate or administration. So you have to establish that you've got some skin in the game, you know. And so in our case, my client could establish that standing by showing that she had an interest in an earlier will, the 2008 will, which is, 3 wills back. And that's why she had to allege that both the 2018 and 2012 wills were invalid. And so she had an interest in that will by way of a legacy. She got, I think, $140,000 under that earlier will. And she also got some personal items in that will. But that's a pretty modest interest, to be honest, in the context of what was a pretty large estate. And in the context of Supreme Court litigation, where it can be quite expensive.
Yep.
And so, but it's enough. You need to just have some sort of interest. And that was enough of an interest for the court to conclude that my client had standing to bring the objections that she was bringing in to challenge the application for probate of both 2018 and 2012 wills.
Yep. So, okay, Jeanette established standing. Then the court then had to determine whether she could establish a prima facie case. Now, that's how I pronounce it. I know there's two ways to pronounce it, and clients don't understand it. But Bryden argued that Jeanette could not establish this either. His lawyers argued there was not sufficient evidence to show that her claim was arguable or could even succeed. So can you explain what is a prima facie case and how did the court determine it in this case?
Yeah, so prima facie or whatever you say. It's just one of those old Latin phrases that we have to deal with sometimes in our work. And so, it's an important part because this whole decision was about that issue, really. It was about demonstrating that my client could show that she had a case to run, basically, which is what a prima facie or prima facie case means. And so the court will assess the allegations that the caveator makes against the will and against the grant of probate or the application for the grant, and we'll look at those allegations and decide whether or not there's enough of a case to actually run a trial about. And so when it does that, the court doesn't determine the correctness of the allegations or the truth of the allegations. It just considers whether those allegations, if they are correct and if they were true, and if they were proven at trial, whether that it would be enough for the caveator, in this case my client, to succeed in rejecting or having the will declared invalid. And so the court uses phrases like it must show a case to investigate or a case for investigation or something to go on, right? So, and the facts need to be considered as a whole. So you don't just look at them in isolation, this happened on this date, is that enough? You have to look at all of the facts that are alleged by the caveator and consider whether there's a case to investigate there. And you usually need to show a causal connection between the facts you're alleging and the making of the will. So you need to show that whatever you say was affecting the testator's ability to make the will, that was actually causally connected. So there was a direct connection between that problem and then the making of the will itself, the will that you object to. You can do that by drawing inferences. You don't need to necessarily show that it's precisely this fact means the will's invalid. You can draw inferences, but you can't speculate, right? So you can't just say, I thought she was old and didn't know what she was doing, therefore how could she make a will? You need more than that. You don't need to prove your facts yet, as I said. You don't need to prove anything on evidence. So you don't need to lead evidence that proves anything. But I think it helps your case at this, even at this stage, if you can show that you do have evidence available to you that supports the facts that you're alleging, which then undermine the will. Yeah.
Yeah, and I want to break this down a bit further and let's look at each of the grounds for objection. So let's start with testamentary capacity. So at the caveat stage, Jeanette needed to demonstrate there was credible material or evidence which raised doubt about the deceased's testamentary capacity. So Jeanette argued that deceased lacked testamentary capacity during the period shortly before and at the time she executed a 2018 will. So can you take us through the evidence or material she had which raised her suspicions about this?
Yeah, and I want to be clear about this. I said that you don't need to show or prove evidence to show these facts are right. You do need to have a proper basis to make the allegations. So you can't make things up. That's very important. You can't make it up because it sounds good and it helps your case. You need to have a proper basis. And then if you can demonstrate that there's a case to run, then you'll probably be successful. But in terms of lack of capacity, my client was quite diligent about this and went to great lengths. And with my instructors in the case, we did a lot of work in reviewing Clarice's medical history. Mm-hmm. And these cases do often devolve, unfortunately, into just reviewing medical documents. And there can be thousands of pages and it can get expensive too. So you need to be aware of that. But in this case, we did that process. Ultimately it was fruitful for my client because of the case. But we went through reams of medical documents and particularly from June 2017 onwards. Mm-hmm. In June 2017, the deceased went into hospital with a physical injury, a broken arm or something. She was in hospital for about 8 weeks. And during those 8 weeks, the doctors made a number of notes and recorded a number of observations about her health and how she was, including capacity issues. And there were numerous notes that suggested that she lacked capacity at different times, that she suffered from periods of confusion, periods of delirium, was suffering from progressive cognitive decline, poor memory, symptoms consistent with dementia and Alzheimer's disease, unable to recognise people. All of those things were in the medical records. I mean, we did extract those parts that were quite useful for our case, but that was important because it went to establishing that she might have lacked capacity when she made the will in 2018.
Yes, you had some medical evidence to support her suspicions. Exactly. I mean, sometimes clients come to us and say, look, don't think mum had capacity. She was pretty old and she was forgetful, but they don't actually have any medical evidence to suggest that she didn't have capacity at that time.
Yeah, exactly. You need to have something. You can't just say, look, I think she was old and, as you say, forgetful. You need to have something more to establish the case. A couple of other things we had. We had a VCAT order that suggested that she didn't have capacity in August 2017. That came up in the case a bit. That was a bit more of a peripheral point. I think the medical documents themselves are much more persuasive. And we had the death certificate itself. Now, the death certificate often records dementia. If someone dies whilst suffering from dementia or with the diagnosis of dementia. In this case, the death certificate recorded dementia from 2 years prior to death. Clarice died in 2021. So the 2 years prior to death took us to 2019. It didn't quite get us into the 2018 time when she made the will. But it's still an important fact that it was clearly she had dementia and that perhaps, and the court recognises dementia can progress slowly and sometimes the diagnosis comes after the symptoms really commence. So those were the facts that we alleged in this case in terms of capacity.
Yeah, and there were quite a few affidavits who supported Jeanette as well. And as you mentioned, the VCAT, the deceased social worker and counsellor, now he saw her in 2017. He formed an opinion that she didn't have decision-making capacity and made the application to VCAT to get a guardian administrator appointed for her. There was also an affidavit by her retired stock agent. Now, he's known the deceased for numerous years. He said in 2017 when he visited her in the hospital, she asked him who he was. And he was shocked by that because he's known her for over 40 years. So based on the affidavits and the medical material, the deceased, you can infer that the deceased didn't really have capacity in 2018. Despite this, Bryden's lawyers argue the deceased did have capacity to make the 2018 will, and they relied on the fact that the deceased will was made by a solicitor. But we know just because the will is prepared by a law firm, it doesn't mean it can't get questioned. How did the court deal with this?
Yeah. Well, you didn't do this will, did you?
No, I did not.
So obviously open to question because your name wasn't on it. But
no.
Now, this is important because I think it's important to emphasise that going to a solicitor to make a will is absolutely the right thing to do.
Yes.
And you're much more likely to make a strong and well considered and viable will if you go to a solicitor and get proper advice about it. Look, in this case, Clarice did go to a solicitor for the 2018 will and her earlier wills. Notwithstanding that, we still alleged, and my client alleged, that it wasn't a valid will because of the capacity issues and the undue influence issues, which we touch on later. But the Atkins, so Bryden Atkins, who was bringing the application for probate, really made a point of saying, well, if the solicitor made this will, surely it's a valid will. And I remember during the oral submissions in the case, when I made the submission that I accept that a solicitor has made this will, Your Honour, but even so, in the circumstances, I say there's a case to investigate it. The judge raised his eyebrow and said, Mr. McCoy, you're telling me we can't trust the word of a solicitor, an officer of this court.
I would go on the side of the judge on that one.
Yeah, well, he was a bit shocked by my submission, but I said, look, in the context of everything else, Your Honour, there's a reason to investigate this case. And I'm not just casting aspersions on the solicitor or disparaging his credit or his character. I'm just saying, look at the facts as a whole. And that's what the court did. It looked at the facts as a whole. And it said a couple of things about the fact that the will was made by a solicitor. One, that fact alone didn't overcome the problems raised by the medical evidence, right? So the medical evidence still existed. There was clearly a concern about Clarice's capacity in 2017, prior to the 2018 will. That was enough for the court to be a bit suspicious about the will and want to see more evidence about it. And so there was a case to investigate based on that. And that the fact that the solicitor had made the will for Clarice didn't cure that problem. The other point that the judge made was, yes, the solicitor has made the will. Yes, the solicitor presumably will give evidence in support of the will and in support of the fact that Clarice had capacity when she made it. But those are issues for trial.
Yep.
And right now, what I want to work out is whether there's a case to go to trial in the first place, whether we need to go to trial at all. And so that evidence will come out at trial. It will be considered in the light of everything else and in the proper procedure. It's not enough to dispel my concerns about capacity raised by the medical evidence.
And look, and that's a good point. Like what the judge says, those matters are a matter for trial. And I think this is where I want to reinforce that having a will prepared by a lawyer, it's not bulletproof, but it's better than a will kit because at least a lawyer can be there, give evidence, talk about the capacity, they took instructions. Your case is going to be a lot more stronger if it's prepared by a lawyer. Now, Brian's lawyers also seem to suggest that the deceased didn't lose capacity until 2020, and they relied on the fact that the deceased was reassessed in 2018 and VCAT revoked those administration guardianship orders on the 6th of Feb 2018. So how did the court deal with this argument?
Yeah, another important point, and I completely agree with what you say about using a solicitor to make your will. It does make your, if this does arise later, it makes the case for the will much stronger. As I said before, this particular issue was being treated by Bryden and his lawyers as a discrete point, right? Taken away from the context of everything else. So they were trying to isolate facts that were alleged against the will and take them away from the context as a whole and say that each of those facts individually are not enough to run a case about the will. The court didn't agree with that. The court said, look, you have to take it all together, right? Consider them all together. In the context of everything that's been put before the court, the fact about the VCAT orders and things is an important aspect of that total narrative. And so the court concluded that, yes, there was some force in the submission about VCAT having then revoked the initial administration order some months later, which suggested perhaps Clarice had capacity.
Correct, yeah.
But the court concluded, well, in the context of all the medical evidence and the other allegations alleged against the will, it's still an important factor to consider that VCAT did in August 2017 consider that Clarice lacked capacity. And that the other point about these things is that capacity, and this is, I think, important for clients, capacity can fluctuate.
Yes.
Right? Especially people who suffer from dementia or Alzheimer's disease. It is well known and certainly well recognised in the courts that illness can change on a day-to-day basis. Yep. I mean, it can be as granular as day-to-day, where people one day will be their normal selves, the next day will not know who their spouse is, who their children are. You know, it's amazing how scary that disease, that illness is. And it affects, will making, because you can't be sure if someone who suffers from dementia makes a will on any given day. The day before, they might have a doctor saying they were normal selves, they looked absolutely fine. You just don't know if on that next day they woke up and they weren't themselves.
Yep. Yeah, correct. And I think too often clients rely on, mum had dementia the last 5 years. There's no way she could have made that will. But as we know, just because she's got dementia doesn't mean she doesn't have the capacity to make a will at that time when she'd made the will or signed the will.
That's exactly. And I think it's important as well, just generally, to treat people with dementia with respect and understand that it's not something that completely incapacitates them forever or for everything. And so it's just it's an education, I think, about the illness, and certainly working in this area has taught me a lot about dementia and how it works. Yeah.
All right, so that was that one ground. Now, I want to move on to undue influence. So at the caveat stage, what Jeanette needed to show was facts capable of supporting inference of undue influence. Can you describe the observations Jeanette made concerning the relationship Stephen had with the deceased?
Yeah, well, this is where it gets a bit juicier. As you mentioned earlier, Stephen was Clarice's farm manager. I mean, he was sort of started as just a farm hand, and he sort of worked his way up to farm manager. When I say worked his way up, it wasn't a particularly long or significant corporate structure or anything, but he became more and more involved in the farming operation that Clarice and her family had run for many years. And that's another thing I learned doing this case. I learned a little bit about farming that I didn't know before, about stock counts and things like that. In any event, the allegations against Stephen were numerous, but they were over a long period of time. So from 2006 onwards, were allegations, and they were based on observations of my client and other members of her family and Clarice's family and people who were close to Clarice, who had encounters with Stephen over time and found them quite difficult. And so the allegations were things like Stephen would monitor Clarice's phone calls and her phone bills and check her phone records, and sometimes he'd intercept her calls. And so the allegation was, he was, controlling who had contact with her. There was allegations of outbursts of anger and violence and furniture being thrown, and Clarice telling my client that she was scared of Stephen at different times. There was one particular allegation based on what Clarice had told my client about. Apparently there was a pay dispute between Stephen and Clarice, and that this led to an incident where Clarice was stuck on the farm in a remote part, couldn't get back without Stephen's help, and Stephen left her there and then came back. And I stress, these are all allegations, and they weren't proven allegations. These are just the allegations that were made in the case, and that the court considered were enough to investigate, but not actually necessarily proved. They weren't necessarily proven. There were allegations involving threats by Stephen's partner, allegations about Clarice being unsure of herself after a lot of exposure with Stephen. She became more and more fragile and vulnerable. There was assault allegations. The police were called and, in fact, allegedly arrested Stephen on one occasion. Other injuries occurred later. So that assault charge, there was no charge, but the assault arrest was in 2012. There were other injuries that Clarice suffered in 2016 and 2019, consistent with other assaults. The inference we suggested to the court was that perhaps Stephen was the perpetrator of those.
But Stephen wasn't charged. That was just okay.
He was never charged. We say, or my client said, that was because Clarice didn't want to provoke the situation further or make it worse. But there was no charges laid. But generally, there were other allegations of aggression towards visitors. So Stephen would lash out at people coming to see Clarice. Again, we say court could draw an inference about him trying to control who had access to her, that he was engaged, surveilling everything she did, and that she couldn't get away, and that he had an interest in her personal affairs in the sense of, apparently when he passed, copies of her wills were found in his possession, so that the inference there is that he was trying to be in control of what she was doing with her testamentary affairs. And this is all in the context of someone who was suffering from cognitive decline, was in her 80s for most of those things. She died at 91 years of age. She was frail, she was vulnerable. And so that adds, I think, a bit of weight to everything. She wasn't someone who could protect herself if this was happening, and particularly if she was becoming more and more reliant on support from one person. If that person then, tried to influence things to suit himself, she would find it difficult to resist that.
Yeah, and look, there was numerous affidavits filed from her friends and family who observed Stephen's controlling and violent behaviour. I mean, there was one from her nephew where he states that he would ring her and she would tell him that Stephen's been roaring and yelling at her. She said that if she did not agree with Stephen, he'll threaten to leave her, and there'd be no one to help her on the farm. There was also numerous occasions where the deceased told Stephen to go home and pack his clothes and get off her property, but she was scared that he would come back and hurt her. Then there was an affidavit from the deceased's niece, Wendy. She stated that she observed Stephen antagonising and swearing at the deceased, and that when the deceased was on the phone call and Stephen would come by, the phone calls would cease. I think the interesting affidavit was from the deceased accountant. Now, he says that she would call him on occasions complaining about the continual harassment and aggressive behaviour by Stephen, and that she felt threatened by his behaviour, which increased each time he would have a blow-up. He also said that from around 2017 onwards, the deceased calls to him increased in length and volume, and that she told him repeatedly that she was scared of Stephen and that he was controlling the farm. I mean, it all seems really consistent with what other people are saying. I think the telling one was when he said that in about 2017, the deceased showed him her 2012 will and told him that it was signed under duress and she was not happy with it. I mean, despite all these affidavits, Bryden's lawyer still argued there was insufficient evidence to show a case of actual coercion on part of Stephen towards the deceased in making her 2012 and 2018 will. Can you take us briefly through what were their submissions about this?
Yeah. And I, just to comment on the number of witnesses, it was quite surprising to me that there were a number of people who were willing to come forward with similar allegations, and I think that added a lot of weight to the case, and it's certainly in the judge's mind, I think, added weight to the case. But in the plaintiff's case was, broadly speaking, that the allegations that we'd raised against the wills were vague, right? And they weren't proximate to the making of the will. So that is, they weren't close to the time when the wills were made. And that, because of those reasons, it wasn't enough to run a case to investigate. The wills were valid on their face, and therefore there's no reason to look behind that, where the only allegations against them were so distant in time and were quite vague. Now, I mean, I didn't agree with that, of course, but and the vagueness point is an interesting one, because you can only go so far when you're drafting these allegations, or at least when you're making allegations that you don't have direct first-hand knowledge of. And in most cases, clients won't have direct first-hand knowledge of what's happened here, because if someone has been doing the wrong thing, they usually manufacture, the result by keeping control of what's going on around the person making the will. So the court will look past it a little bit, as long as you can show that there are real questions to be answered. And again, the fact we had several witnesses really helped. So the plaintiff said, vague allegations, but also no evidence of actual coercion. Probate law, when it comes to undue influence, requires actual coercion. An important aside in this case, the court concluded based on inference there was enough of a case to run on coercion, which was it's a little bit of a loosening of the test, I think, from the older authorities. The plaintiff also said there was no critical nexus between the allegations and the making. That's the point I made about timing, right? There was no connection in time, and that the allegations were speculative, although the plaintiff admitted there was a complex relationship between Stephen Atkins and Clarice. And again, the plaintiff emphasised that it was important that Clarice attended solicitors to make her will. But we've addressed that, and the court addressed that quite clearly in its reasons. So that was the plaintiff's case, and it's the pretty standard case of someone who's defending allegations like this against a will.
Yeah. And look, and the court considered submissions of both sides and concluded that Jeanette had established a prima facie case that the deceased lacked testamentary capacity when she made the 2018 will. They also found that she made out a prima facie case that the 2012 and the 2018 will were made by the deceased as a result of Stephen's undue influence. So tell us your key takeaways from this case as you were involved in it.
Yeah. Right. Look, it was a really interesting case.
Yeah.
It was a good case to be involved in. It ran for some time. It took us a while to get to this point. And this is, again, emphasised, it wasn't the trial,
yes.
right? It wasn't, the court wasn't deciding the truth of the allegations. The court was just determining whether the allegations were enough to run a trial at all.
Yep.
And fortunately for us, the court concluded that, yes, there should be a trial about this case. Now, the trial never went ahead. There was a settlement done subsequently, and that's for the best for everyone, frankly. But it's an important case for several reasons. I think one is that the importance of the medical evidence on testamentary capacity cases. Now, medical evidence at trial can be overcome by the evidence of a solicitor who saw the testator obviously at the time they made the will, took instructions, drafted the will, got the instructions the will was accurate, correct, in line with the instructions the testator had given, and the solicitor formed the view and thought about capacity, formed the view that they had capacity. That's really powerful evidence in favour of capacity. But in this case, because we were only on the prima facie case level, the medical evidence really did raise suspicions because Clarice was suffering from dementia. There were clear symptoms recorded in her hospital notes and hospital records. There was a real doubt there in the mind of the court as to whether she could make a will. And so that was really important. And you have to be careful. You really should go through the medical evidence carefully because I think it's important if you think there's a real issue with capacity. Another aspect, consider the case as a whole, right? All the facts as a whole. Don't isolate facts and think, is that enough? Is that enough, individually? And there's a Court of Appeal case called Gardner and Hughes, which says this is really important. Consider the case as a whole, and if the case as a whole establishes a case for investigation, then you're very likely to succeed on a prima facie case argument.
I think that's important. Clients need to understand you've got to have enough evidence there to warrant an investigation. That's really the benchmark that they've got to get over, rather than going, I don't think she had capacity because she was sick or she forgot her name or she left the stove on.
Yeah, or another one I hear a lot is, mum told me in, 2005 that I was all going to be even or was all going to be split evenly or that I was not going to leave anything to so-and-so. That's not that really isn't relevant.
Yeah, it's
really
not
relevant.
It's not enough.
Yeah, no, it's not enough. So, but if as a whole, if there are other things to run on, some of those facts can become important if in the context as a whole they seem unusual or they add to a narrative that suggests lack of capacity or undue influence or something. The other points about this case I want to emphasise, a case against a will can be established on inference. It doesn't have to be, direct evidence of watching someone actually hold a gun to somebody's head when they make their will. You can draw inferences. That's important. Collect evidence far and wide. So talk to as many people who might have a connection with the testator as you know.
Yep.
In this case, as you mentioned, Linda, we spoke to the accountant, we spoke to the stock agent, we spoke to family, and we spoke to the social worker. Lots of people who gave us really corroborative evidence for our case, which was important. And then I'll say it again, it's really important that everyone understands this. This was only establishing a case to investigate. It wasn't the trial of the facts. So there were no findings about these allegations by the court. All the court did was make a conclusion that the allegations themselves were serious enough to require a trial. So serious enough to be tested in a proper trial with evidence and examination in chief, cross-examination and all those things. So that was the point of this case.
Great. That's a great summary. Thanks, Jono.
Thank you.
And that is today's spill. So thanks for sipping along with us on the Wills and Spills. Join us next time for another cocktail, another case and another story worth unpacking. Cheers.